Education is preparation for reparations.
We're going to go straight to our next speaker, who is Jacqueline Mckenzie, a partner at Lee Day, but very importantly, one of the partners for whom which we wouldn't have been able to put on today's conference. So thank you so much, Jackie, and we're very pleased to hear you speak.
Thank you, Chair, esteemed panellists and conference participants, all protocols observed. I'm really grateful to you, Val, for bringing together such a diverse group of expert voices to explore our understanding of reparations, to outline the nature of the work that we need to do so that we can learn from each other, and to agree a series of recommendations or a methodology for synergized working across our different expertise and themes so that we achieve the aim of reparations, the ill consequences of the transatlantic system of the enslavement of Africans. My firm, Lee Day, long involved in matters of community and social justice, is delighted to be a main sponsor of this conference, and I'm delighted to provide an insight into my thinking and a little bit about my work on reparations. Firstly, though, we appear to have entered an era where the demands of reparations are heightening globally, and the matter has become critical as those nations and communities affected by the transatlantic system of the enslavement of Africans continue to suffer from the consequences of that system. I want to start by acknowledging and giving due respect to the reparations campaigners who have been working for decades to seek reparatory justice for the lives lost, the brutality of the transatlantic system, the loss of opportunity for Africans in the Caribbean, the Americas, Africa, and the diaspora, the destruction of identities, cultures, and economies, all of which have consequences which last to this day. The consequences of underdevelopment, underattainment, inequality, and racial mistreatment, situations made worse by the impact of climate consequences, the desperation of white supremacy, and the worldwide economic crisis with its resulting social crisis. There are counter views on what reparations is and means, who the legitimate voices are, whether or not there's a legal, moral, or political case, or a combined approach, who should receive it, whether it should be money, projects, the development of infrastructure, debt forgiveness, restoration of artifacts, etc. The critical observation to be made, though, is that reparations must feature at its centre the victims of the perpetration of the biggest crime against humanity. There is no legal provision which determines what reparations is. In international relations theory, it is regarded as a concept rooted in international law that involves specific forms of repair to specific individuals, groups of people, or nations for specific harms they have experienced in violation of their rights. The system perpetrated represents a brutal and effective campaign which built the wealth and unjustly enriched some nations at the expense of others, and which resulted in a race of people losing their very being of self, which heralded in racism and inequality with an impact which reverberates today with the destruction of our cultures and our histories, which existed before the transatlantic system, a system which reduced the lives of Africans to that of a resource. People became a currency and expendable. To make that happen, our ancestors were subject to the most abhorrent brutality. Africa and Africans lost their prior civilizations, which consisted of strong and powerful political connections, economies, trading arrangements, education and scholarships, arts and culture, and developed family structures. We know that supernormal profits were made from this system, with those profits continuing well into the era of colonialism and today. And we're all very familiar with the revelation that the Treasury was repaying interest on loans obtained to pay off our enslavers just as recent as 2015. And I wouldn't be surprised if it's still continuing. Reparations means recompense. Thank you. I've got the dry subject to deal with, I'm afraid. You're not going to get the excitement from me as you're getting from the other speakers. Reparations means recompense given to one who has suffered legal injury at the hands of another to make amends, provide restitution, or give satisfaction or compensation for that wrong. It also refers to the thing done or given to the injured party, And we're struggling really to determine what is it exactly is it we're talking about. The United Nations Basic Principles and Guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations, that's actually the term, describes 5 formal categories of reparations, and they are restitution, compensation, rehabilitation, satisfaction of the wrong, and reassurances, meaning it will never happen again. In the discourse and practice on reparations, we're seeing institutions and families entering the space with pronouncements about their past involvement in the transatlantic system of the enslavement of Africans. These are initiatives which have been extremely helpful in raising the profile of the cause and so therefore welcomed, but we must sound caution if these initiatives come to dominate and worse, distort the meaning of reparations and move us away from the requirement to provide. Move us away. I'm racing because I thought I had 15 minutes, so when I got here I heard it's 6. So move us away from, 7. I've just wasted one. And move us away from the requirement to provide repair and atonement to the victims. So what we're seeing with pronouncements from institutions like the Church of England Commissioner, who set aside 100 million and have put out a survey, even though they say that this money must be spent on projects aligned to the Church's missions. How is that reparations? We have the Bank of England. And who's completing this survey? How's it reaching the people who need to have this repair? We have the Bank of England, who admit to owning plantations on the east coast of Grenada. We've got Balliol College at Oxford, who announced just this year that its wealth originally has been built on injustices like slavery and other forms of exploitation in subsequent centuries, and sought to quantify this, and actually came up with quite a measly figure. And unfortunately I forgot to look up the figure. I was actually in the audience and forgot to note the figure, but it was quite measly. I thought, well, hold on a moment here, where does that come from? You're making it, it's almost as though these organisations want to dictate this discourse, and they want to tell us what reparations is, how much you're going to get, and absolve their future generations from any further involvement or responsibility. And I kid you not, King Charles signalled his support for research into the British monarchy's historical links with transatlantic slavery after the emergence of a document showing a predecessor's stake in a slave trading company, which apparently took him by surprise. Of course. Most students of the numerous black-led supplementary schools across the country could probably school our king. And the heirs of slavery, who as individuals have pledged sums of money to various reparations committees in the Caribbean, their work's important and instrumental in raising profile, but who are these reparations committees? Who are they accountable to? So there must be more discussion on this. My work as a lawyer is currently looking at the work of CARICOM and how CARICOM takes this forward, CARICOM being the union of 14 Caribbean states. CARICOM recognises, though, that it cannot and should not be seeking reparations on its own accord without examining the consequences for Africa and Africans in the diaspora. In recent months, there have been a number of... I haven't got time to repeat it, Kwaku. In recent months, there have been a number of high-profile meetings in the region where delegates from the AU have met with leaders, lawyers, activists and academics in the region to work together, and there is now a joint working commission across the AU and CARICOM, which I am joining as a lawyer. Lawyers work on specific causes, this does not undermine the importance of recognising the Pan-African requirement of reparations and the need for repair to include those countries in Africa who were impacted, those countries in the Caribbean and Latin America who were impacted, and the descendants of those people who were transported from Africa wherever they may be in the world. What reparations may look like is beyond the scope of my introductory words here today, but it is something we must discuss. One of the things us lawyers do when deciding on strategy for any case is to look at how realistic an outcome might be. We may have our minds the egregious nature, sorry, don't worry, I'm not going through this entire paper, I am skipping bits. We may have in our minds the egregious nature of this brutality. However, we are going to have to set parameters it's my view, and I look at Elder Cecil Gutsberg over there, and I bow to Esther here, because they may disagree with me vehemently, but I think a lot of this work will probably remain outside the court and around tables in negotiation or arbitration, perhaps with some really dreadful organisations and individuals. We have seen some recent legal setbacks. The reparations case for Tulsa race massacre was dismissed by Oklahoma judge Caroline Moore, who dashed an effort to obtain a measure of legal justice by survivors of the deadly racist rampage that left hundreds of black residents dead in 1921. And there are survivors who brought that case, let alone what we're looking at. The Court of Cassation, I think that should be cessation, I can't read my own typing, France's highest court of appeal, recently rejected a claim for reparations to be paid to the descendants of people enslaved under the French Empire. While France recognised slavery as a crime against humanity, it denied all requests to compensate the relatives of those victims. Those of us who work in the area of human rights law in particular, without wanting to attract any further venom, often raise an eyebrow at how truly separated are our executive, judiciary and legislature, as discussions about floodgates, numbers and money always seem to conflict with the rule of law or the general regard for safeguarding of human rights. And we'll have that fourth estate, the media, riling up its base against us. You hear it in the phone-in programs. We're not paying our taxpayers' money, it was nothing to do with us, that sort of thing. But there is no doubt that the transatlantic system of enslavement of Africans was unlawful. Our defendants will continue to say that slavery was legal and therefore reparations is unwarranted. There are even those who will go as far to say that chattel slavery, when one is deemed a piece of property with no rights, was precluded from any protections enshrined in law. The notion has the effect of effectively saying that Africans were not humans. And of course, there are jurists on the side of reparations who discuss the absurdity of such a notion so as to render any relevant treaties or declarations null and void, and that we should be seeking a declaration to that effect. Slavery is deemed one of the 12 crimes against humanity. I'm going to completely skip the Durban Conference and some bits of the legislation that we've been looking at, because I've had my 1-minute signal up by my boss here. But just the UN Special Rapporteur on Racism, the UN Working Group on Experts of people of African descent and who have been looking at Durban and the consequences for Durban, continue to demand formal apologies, truth-telling processes, and reparations in various forms. So I'm just going to conclude. The British will say that slavery was legal, but there is no pronouncement there is no law providing for slavery. And we understand that this can only be lawful if there is some positive law. I have some case law which I will deal with later in my workshop on it. But for the slave codes must have been unlawful. No one tested them because there was nobody available. How were the enslaved people going to bring these cases against their own rights? I'm going to have to stop, but if you do want to know a little bit more, I want us to look at the Somerset versus Stewart case and some of the issues that I've been discussing with my elder Cecil about the law. We do feel excited about looking at a legal avenue, more so than we did previously. But just to finish, we must have a commission of our people established to deal with reparations, and it must include people who are subject to the ongoing Mckenzie, as Esther will describe it. Kimani talked about the need for strategy and scholarship, and that is so disparate in this space, and so we need that. We need to build a movement. We need our lawyers to sit down and look at bringing cases, because we know the judges are going to be averse to wanting to make brave and bold decisions. And we need to have sectoral groups of experts within our community coming together to look at the law, to look at arts, culture, archiving, history, and so forth. And I think I saw a little hand there, so I will stop, but thank you.
Thank you so much, Jacqueline.
Education is preparation for reparation, yeah?